When someone passes away and the families come to me after they've passed away, one of the first questions can be, like, what do we do now? And if you are named the executor or personal representative in someone's will, that responsibility can be a little bit overwhelming feeling, but it doesn't have to be. So let's kind of go over what it looks like to have to administer a probate in Washington State. I'm Darcel Lobo. I'm an attorney and the owner of Dow Law Firm in Normandy Park, and I've been helping clients for almost 17 years now navigate probate and all things estate planning with wills and trusts and power of attorneys. And so we're going to go over today that role that you may have if you were the one named in somebody's will, and kind of what probate is, and kind of a higher level view of what probate actually looks like. So, probate itself is a court process used to, we call it settle someone's estate, but what that really means is to liquidate their assets, pay any debts they have, and then make distributions to the beneficiaries or heirs in the will. And so, your job as the executor is to manage that. So, to identify all the assets, to liquidate them, if there are any debts, to pay those items from the estate, and then make those distributions pursuant to what the will says. But in order for you to be able to do that, because you have a will that says you are the one that's named as executor, but that does not give you the right or the ability to then go and act. You need what are called letters testamentary. So if you've gone to a bank or other financial institution to try to get access to those accounts, you've likely been told, no, you need letters testamentary. The way you get letters testamentary is through probate. So you first need to open probate by filing the will and some original documents with the court, primarily a petition asking the court to admit the will to probate and to appoint you as the executor of the estate. And I'm going to be using the term executor and personal representative interchangeably. They both mean the same thing. And so asking the court to appoint you pursuant to what the will says, that it names you as the executor. Once the court has signed that order to have you appointed, then the clerk of the court is going to issue you the letters testamentary. That is a one-page document that appoints you as the executor of the person's estate and shows kind of what date you were appointed and what your powers are, and to be able to act on behalf of the estate. So once you have your letters testamentary, then you can start acting and doing things on behalf of the estate. And one of the first things you'll want to do is probably get a tax ID number for the estate, because you may need to open a bank account for the estate to close out the decedent's individual bank accounts and other financial accounts that did not have beneficiaries, and move those funds into the estate account. Once you've kind of gone through that process, you got to make sure you notify any creditors. So you're going to be reviewing the decedent's mail and other records to see what credit cards did they have, what loans did they have, what final medical bills did they have, and give all the creditors notice that the person has passed away and that probate has been opened. You should also probably publish the notice in the local newspaper. It has to be a legal publication for at least 3 weeks. That's going to shorten the timeline that any creditors have to file a claim against the estate to get paid. And so you'll file that publication in a local legal newspaper. If you're in King County, we use the Daily Journal of Commerce. That's what I suggest to all my clients that we use. It's about $135 for that publication, for Daily Journal of Commerce, to get that publication out. It is not required, but it's highly recommended that you do so to, again, shorten that timeline for creditors to file a claim to get paid from the probate estate. So you're going to pay those any final debts or expenses. You're going to file the decedent's last tax return. If the estate needs a tax return, you will do that as well. So you should be talking to and working with a bookkeeper or a CPA to help you with that. You want to make sure you're keeping clear and organized records of what you've found as far as assets, as far as debts, what you've paid, things of that nature. So make sure you're kind of keeping a pretty good ledger of those items. And then once you have completed those steps, so you have liquidated all the assets, you've paid any debts, final expenses, any probate expenses have been reimbursed if anybody paid those out of pocket, or even like funeral expenses. Anyone that paid those out of pocket, those would be reimbursed off the top. And then distributions are made to the heirs once you have passed the probate notice creditors period, and you have all what you believe as far as all the assets and all the debts that are known at that time, and you're ready to actually close probate, then you'll make distributions to the heirs. And so you'll make distributions, you'll file your final report with the probate court saying, this is my declaration of completion. I have completed all the steps necessary for the probate in this estate. And can you please, judge, go ahead and close probate for this case? Most probate cases I see take about a year, assuming they're uncontested, there's no disputes. At a minimum, if you do the creditor notice period, which goes for 4 months, it's probably going to be about 6 months from start to finish. But I usually see about a year because you need time to go through the files and records of the decedent and to file the tax returns. And there's just a lot of steps that need to be done. And depending on how organized the decedent may or may not have been, that can just add to the timeline of how long it takes to kind of get through all of this. And then also for a lot of my executors, they have full-time jobs. They have families. They have other things going on as well. So I just tell my clients, plan for about a year, no sooner than 6 months, generally speaking. It can go longer. If you have multiple properties to sell, you've got businesses that need to be liquidated or sold, it can take longer sometimes. And if it's contested or disputed, it certainly can take longer. Our office does not handle any contested or disputed probates. We refer those cases out. When it comes to probate itself, I have developed an online program called Welcome to Probate to help people who want to navigate probate on their own, but would like a little guidance, a bit of a roadmap as far as what to do, how to do it. And so it's broken into 3 sections: preparing to open probate, opening probate and administering the probate, and then closing probate. So I give you all the documents you need, all the pleadings that you need. There are video lessons for every phase of the probate process. I have done videos kind of recording what you need to do and how to do it. So it really is your roadmap to navigate probate on your own. So if you think that might be a good fit for you, we'll have that link down below for you to learn more about the program. And if you need help with a probate, given our current capacity, sometimes we are unable to accept one-on-one representations, full representation, and a probate depending on kind of our caseload. I am a solo attorney, so I'm the only attorney in the office, and I have my support staff, but we only have so much capacity. So if you reach out to get full representation in a probate, we may have to refer you to another firm depending on kind of what our caseload looks like. But if you want to learn more about doing it on your own, I'll have that link down below. And if you need a referral for a contested or disputed probate, when maybe the heirs are not in agreement or there's some disputes over a will, we can give you some referrals for that as well. Our office would not be able to help with that matter. So again, I'm Darcel Lobo. I own Dow Law Firm. I hope this is helpful. I'll see you in the next one. Okay.